All right, welcome to this explainer. Today, we're untangling a massive, top-trending real-world legal issue. Exactly what happens to the family home when a marriage breaks down in British Columbia. As a practicing barrister and solicitor with active memberships in both BC and Ontario, I see firsthand just how heavily public anxieties weigh on separating couples. It's incredibly stressful. Now, I want to be super clear right off the bat. The legal rules around common law property and matrimonial homes differ significantly between British Columbia and Ontario. They are very different beasts. So for today, we are zeroing in entirely on the BC statutory framework. We're going to break down the complex laws, the really common misconceptions, and most importantly, the strategic solutions you absolutely need to know. Because honestly, when your most valuable asset is on the line, you literally cannot afford to be guessing.
Okay, let's dive right into this with a very common yet kind of terrifying real-world scenario. Imagine you and your partner are separating. You sit down, you both agree it's best to sell the family home, split the proceeds, and move on. Sounds reasonable, right? But there is a massive catch. The house is only registered in your partner's name. You helped pay the mortgage for years. You practically rebuilt the kitchen yourself. You lived there forever. But on paper, your name is nowhere to be found. So who legally has the right to do what here? Can your ex just list the property and sell it right out from under you? Does the simple fact that you're married or in a common law relationship automatically protect your investment?
Section 1. The unregistered spouse problem.
To really grasp this unregistered spouse problem, we first have to look at the massive legal tension between BC's real estate rules and its family law statutes. It's basically a tug of war. Real estate law wants speed and certainty. Family law wants fairness and equity. Under the Land Title Act, BC operates on a system with a core principle called indefeasibility. Now, in plain English, that simply means what you see on the land title is exactly what you get. No hidden surprises. Section 23 of the Act essentially states that a state of title certificate is conclusive proof of ownership, period. If the title says your ex-partner is the sole owner, the real estate market and the legal system treat them as the absolute, unquestioned owner. And the system is designed this way for a good reason, so buyers don't have to hire private investigators to figure out who actually owns a piece of land before they put an offer in. But here is where the heavyweight clash happens. While the Land Title Act says the registered owner is the absolute boss, the Family Law Act steps into the ring with a totally different set of rules. Specifically, Section 81 of the Family Law Act states that the moment you separate, a spouse, and remember, in BC that includes married spouses and those in a marriage-like relationship for at least 2 years, instantly gains a right to an undivided half interest in all family property. So instantly upon separation, you legally own half of that house under family law, even though the Land Title Act is over there still screaming that your ex owns 100% of it. You now hold what we call an unregistered interest.
And this right here creates a huge problem. It's something we can call the innocent buyer loophole. Let's say your registered spouse gets angry, goes rogue, and secretly lists the house. A buyer comes along, checks the official title, sees only your spouse's name, and buys the property. Under the law, that innocent buyer, someone who had absolutely no idea about your messy separation or your unregistered half interest, is legally protected. The sale goes through. The buyer gets the keys to the house, and you, the unregistered spouse, you are left completely out in the cold, forced into a massive legal headache trying to chase your ex for the cash rather than just keeping your physical property secure.
Section 2. Shielding your property rights.
So, if your name isn't on that deed, how do you actually protect your share from being sold out from under you? Well, you absolutely cannot just rely on the fact that you're separated to magically protect you in the real estate market. It doesn't work that way. You have to take proactive, concrete legal steps to bridge that gap between family law and real estate law. You need to use one of your strongest legal shields, Section 3 of BC's Land Spouse Protection Act. By filing a formal entry against the family residence, you create an absolute brick wall roadblock. Any sale, transfer, or mortgage made without your explicit written consent is immediately void. It legally paralyzes the registered owner's ability to sell the property behind your back.
Alternatively, you have another incredibly powerful tool in your tool belt under Section 99 of the Family Law Act. If you and your spouse have entered into a property agreement, even just a basic preliminary separation agreement, you can file a notice of that agreement directly in the Land Title Office. The second that notice hits the title, the registrar will completely freeze the property. They will literally block the registration of a transfer or a new mortgage to anyone else unless both you and your ex officially sign and file a cancellation notice. So both of these tools effectively do the same vital thing. They turn your invisible family law rights into a highly visible, totally enforceable real estate reality.
Section 3.
The lawyer's conflict trap.
Okay, so let's say you avoid that whole secret sale nightmare. You amicably agree to sell and split the cash. To save a few bucks, you think, hey, let's just use the same family real estate lawyer we used when we bought the place to handle the paperwork. It seems super logical, right? Why pay twice? But here is the twist, and people get so frustrated by this. A lawyer actually must refuse to act for both of you in this scenario. They are strictly bound by Rule 3.4-1 of the BC Code of Professional Conduct. In legal terms, the second a couple separates, their legal interests immediately diverge. Even if you are getting along perfectly right now, one of you is technically the seller, holding the registered title, and the other is holding a very vulnerable, unregistered half-interest. If a dispute suddenly blows up over the payout or the timing of the sale, one lawyer simply cannot advocate for both sides. It's impossible.
The 2026 BC Real Estate Practice Material is incredibly clear on this point for legal professionals. When a buyer's lawyer sees that a property is being sold due to a separation, they are instructed to insist that the selling spouses be separately represented. Now, I see clients constantly resist this because obviously they don't want to pay two sets of legal fees, but trying to cut corners here creates a massive legal conflict of interest. The risks of having one lawyer accidentally bungle the division of the proceeds or fail to properly discharge that unregistered interest we talked about far outweigh the benefit of saving a little bit of money on fees. Separate representation is literally there for your protection.
Section 4. Navigating a legal sale.
So taking all this in, how do everyday Canadians actually navigate this incredibly complex intersection of property law, family law, and professional ethics safely? Well, it requires stripping the raw emotion out of the transaction and treating the family home exactly like what it is, a highly regulated, multi-layered legal asset. Here is your step-by-step game plan. First, the very moment separation occurs, protect the unregistered interest. Do not rely on trust alone. File a notice under the Family Law Act or an entry under the Land Spouse Protection Act, so the official title reflects your reality. Second, swallow the extra cost and secure independent legal representation. You need a professional whose sole duty is to protect your half of the equity. Period. And finally, only once your individual lawyers have drafted the correct discharge documents do you proceed with lifting the encumbrances and completing the sale cleanly and legally to the new buyer.
Remember, when relationships end, the law requires absolute clarity. The systems in British Columbia are absolutely designed to protect you, but, and this is a big but, only if you actually pull the levers provided by those statutes. You know, you wouldn't leave the front door of your physical house wide open for anyone to walk into, so definitely don't leave your legal title wide open either. I'll leave you with this to chew on. In a province where a family home is very often a couple's multi-million-dollar nest egg, are you entirely sure your name is protected on the title today?